as I was preparing for this talk today, and as a lot of you know, I've done this talk, I hate to say how many years in a row, but quite a few years, Environmental Regulations and Nuisance Case Update. And as I was preparing for it, I thought, you know, this is one of those years when I really could stand up here and say, nothing's changed, everything looks good, keep doing the good job you're doing, now let's go enjoy the Pork Congress or whatever. But then I realized they wouldn't pay me as much to do this talk. So I quickly traced that thought and got busy and put together a set of slides, which let me start with that. If you didn't when you came in, please do so now. There's a copy of the slides I'll be speaking from on chairs inside the doors on each side. If you don't have them, maybe Tyler or someone will get you a copy because I will be using those. Also, we are on Swinecast today, as we have been the last few years. So we're being taped. During the talk today, as I've done in past years, I will be glad to take questions as we go along. I think that's the best time to ask questions. I will try and repeat the question so it shows up or we can hear it on the tape. I will also, at various times, probably refer to or call on people in the audience that I either value the knowledge they have or I want to put them on the spot or one of those things. Gene Tinker is here from the Iowa DNR. Raise your hand, Gene. I also reserve the right, Gene just asked me if which category does he fit in, and I reserve the right not to answer any questions we get today. So, now, Gene's always a great addition to these talks because Gene being the Animal Feeding Unit Operations, I said that wrong, Animal Feeding Operations Unit Coordinator, right? With the Iowa DNR and works obviously a lot with livestock producers. And now, in case Gene tries to set me up here, I did call Gene last week and I said, Gene, any hot button issues I need to be aware of and talking about? He said, no, everything's fine. Tell them they're doing a good job and move on. So if he pulls something out of the hat today, I just wanted to at least lay that disclaimer. Also in the audience today, and if I miss someone, I'm sorry, but we have Kent Maurer with the Coalition to Support Iowa's Farmers. Kent, go ahead and either raise your hand, stand up. Many of you know Kent. Kent works, again, with the Coalition to support Iowa's farmers. You're out meeting with farmers, working with them on regulations, etc. Many of you have probably worked with him. And I also called Kent and said, or I think Kent called me, but and I said, Kent, anything I need to be aware of here? And he said, nope. So if somebody tries to nail me with an issue, I've set them up. I've covered my bases at least. So with that, why don't we go ahead and get started? And again, I'll be speaking from the slides, and they'll be on the screen, of course, and you have a hard copy. And in fact, what I'd like to do, I don't usually use my hard copy much, but just to kind of give you an overview, and then we'll get into it. If you look at your hard copy, page 1, and I've got the slides numbered in the lower right-hand corner. The first, I guess, 3 slides down to slide 5 will be about nuisance cases. And I think, for Iowa anyway, good news there. We'll talk a little bit about that. Not good news if you're one of the 2 operations that are being sued for nuisance but overall, good news. Then starting with slide 6, and you go all the way over to page 5, slide 25, that's about the EPA CAFO rule. And again, I could sum that up by saying, folks, no matter what you've heard from EPA, anyone else, right now, for confinement operations in Iowa, don't do anything. Sit tight. The courts keep telling EPA they can't do what they've been trying to do. Sit tight. Don't worry about an NPDES permit if you're a confinement operation right now. And that would sum it up. But I've got several pages of slides. We'll go through the history of that and how we got where we did. And the game's not over yet, but that's generally where we stand right now. Then on slide 26, I guess through, I guess it's slide 38 on page 7, what I want to do is cover DNR rules that, this is just a selected few of the regulations I want to talk about, and mainly what it is are the new regulations that went into effect a year ago in September of 2010. Now, in past years, I've went through a lot of detail on this size operation needs to do this size operation needs to do that. This year, I thought, let's just talk about some of the rules that went into effect last year that I want to make sure everyone's aware of. We talked about them last year, but we should cover them again. And then, if you're working with producers, if you are a producer and you're seeing something in DNR regulations that you have a question about, or anything we talk about today, please ask the question as we go. Then on page 7, slide 39, and through the rest of it will be some general topics, but slide 39 on over to page 8, slide 45 are manure application on snow and frozen ground. And fortunately for a lot of us in Iowa this year, we haven't had to worry about it because it hasn't had snow on it and it hasn't been frozen. But we are in that period of time, and nothing new on that this year, but I think we need to cover that because we get questions about that every year, and it's something producers need to be aware of. Sometimes when we don't have to use something for a while, we kind of forget what it says. Then I'm going to end up with some short discussion on stockpiling for the hoop buildings. I'll use that as a general category. Appeals to EPC on page 9, and talk about environmental self-audits briefly. And then I'm going to finish up with, time permitting, on on-farm oil spill prevention plans. That's not a livestock issue necessarily, but many of you livestock producers should be aware of that, and we have some good news there, and that is the deadline has been extended to update those plans to May of 2013. Not May 2012, May 2013. I love those extensions like that. So anyway, that's where we stand, and that's what we want to cover. Any questions before we dig into the details? First slide, I want to talk about a resource that's available, and I know there are quite a few resources out there. This is something that we put together at the Iowa Pork Producers Association, worked with others on it in the past, and right now we're, Iowa Pork are the ones updating this, and it hasn't, I've got some updates ready to go on the website. They aren't on there yet, but it's the Iowa Environmental Regulations Handbook. In years past, starting in, I think, in 1996, we did it in hard copy. We updated it once, I think, in late 90s, somewhere in there. And now, as of last year, it is on the Pork Producers website. I've given you the web address there, a nice short web address for you, right? But also, up here on the by the podium, I printed out a copy of the web page that show where it's you got to go through a few spots in the Pork Producer Association website to get to it. But if you want to grab one of these, it shows you the page you'll come to. Again, it's the Environmental Regulations Handbook, and it goes into quite a bit of detail. I'm always open to comments if we need to go into detail on something else, but it's pretty lengthy, and it covers a lot of stuff in detail that I won't get to today. The 2 chapters we have up right now are DNR construction requirements and DNR manure management requirements, which covers manure management plans, etc. Updates on these chapters and other state and environmental regulations and nuisance are coming, which is a nice way of saying I haven't got it done yet. So we'll get those updates on there soon, and we will try and keep these chapters updated. There's the web address. So if that, and again, I truly am interested for those of you who have used it or are using it. If you see, obviously, if you see something on there that doesn't look right, let me know. Or if there's a topic that you think we could better explain or something to add, please let me know. Shoot me an email. We're interested in making that a very usable resource for consultants, farmers, etc., that need somewhere to look for some discussion of the environmental regulations. All right. I want to start with the discussion of nuisance cases in Iowa. I have to start with a disclaimer here. You've heard me say this before. There is no place you can go in the Iowa court system to plug in the term nuisance, at least not yet, maybe the day's coming, but there's no search you can do for nuisance, all counties, and find out if there are what nuisance cases are on file in Iowa. You can't do it. This list, and fortunately for livestock producers, it's a short list, are the cases I know of. If you know of any, let me know. Again, I'm not trying to stick my nose into people's personal affairs. The information I have here is basically what's on the website, the court website that's available to everyone. Some of the information, more of it's available to attorneys and others who subscribe to it. But again, as far as I know, that no cases went to trial in 2009, 2010, 2011. Actually went to trial in Iowa for an ag nuisance on odor, etc. Several were scheduled for trial in 2011, and they were settled prior to trial and ended up not going to trial. And most of the time, those settlements are confidential. So even if we knew, that information is not available. The two I know of right now, there's one. They are swine nuisance cases. One in Alameda County, a 2,400 head finisher. The case was filed September 26, 2011. Jury trial scheduled March 6, 2013. So that's the current schedule for that trial. And then one that just was filed on January 5th, 2012. Just learned of this case, and it's in Dallas County, and it's a 2,480 head finisher. And a jury trial has been requested by the attorneys filing the lawsuit, but no trial date yet. So, you know, you always you want to knock on wood, and I'll do this or whatever. Don't want to jinx ourselves, but in Iowa right now, this is very good news. Obviously, if you're one of these two operations, it's not good news, and I don't mean to say anything. Going through a nuisance case as a defendant is not a pleasant experience, even if you win. It is just something no one should want to go through. But absent for those people these two who are going through it, it is good news in Iowa for the number of cases we have. Other states, including the state just to the south of us, Missouri, is seeing a much different story right now. Many nuisance cases on file in that state. Illinois has seen a lot of nuisance cases, more than we have as other states. Again, I don't want to jinx this. I hope it means we're doing something right here. I'm not saying the other states are doing something wrong. It wasn't that many years ago, and it seems like every time I say 4 or 5 years ago, that's kind of my standard line, and then it turns out to be 8 or 9 years ago. But it wasn't that many years ago that I was being asked as an attorney to come to other states and talk about all the nuisance cases on file in Iowa. Other states were looking at us saying, boy, a lot going on in Iowa. Tell us what's going on. There were a lot of nuisance cases on file here. Now it's the other way around. We're the ones without many nuisance cases, and they're experiencing what we did a few years ago. Again, I don't want to jinx this. I hope it means we're doing a good job of citing, a good job of management, a good job of neighbor relations, and all I can say is let's keep it up. Okay? Towards that end, a few what I would call steps to help avoid a nuisance lawsuit. We have and these factors, invariably when I talk about these, and I am an attorney that is, I do represent livestock producers in nuisance cases, and you don't know how many times I've had this slide or some article I've written and given advice to producers to try and help them avoid nuisance cases. I've had attorneys in cases where I represent the defendant try and throw this at me of, oh, did your client do that? Did your client do that? Well, I'm not going to stop talking about this stuff, folks, because it's good advice to everyone. Can everyone do this? No. There are some things that will work, some things that will not work. But I'm not going to stop talking about what producers need to do, or at least take a look at, to try and avoid a nuisance lawsuit. And the one thing I've learned over the years in working with producers in nuisance lawsuits, that when they are sued, they feel they're a failure. They feel I didn't do something right. Because if I would have managed my operation correctly, or if I would have done everything I should have, I wouldn't have gotten sued. And sometimes, unfortunately, it's just that producer's bad luck to have the wrong situation, wrong place at wrong time. You shouldn't stop trying to do everything right, but just because you do everything right doesn't mean that you still can't get sued. With that, again, the list I have here, location, often there is no substitute for a good location. Kent, I know on behalf of the coalition, you go out and try and work with producers using the CAM model, the computer-assisted, I forgot what CAM stands for now. There we go, community assessment model. You'll plug in information. You can spit out a printout that'll tell them what the prediction is. It's not a guarantee, but the prediction is about odor levels at certain residences in the area. It's a tool. It's a planning tool. And it doesn't mean that you're not going to get sued. It doesn't mean you may not have some problems, but it gives you a good idea of what to look at when you're planning an operation. And that's still available, right, Kent? Yeah. Kent said, thanks to Iowa Pork Producers Association and Iowa State University, it's still available. If you're wanting to use that service, get a hold of the coalition to support Iowa's farmers. Location means separation, the actual distance, prevailing winds. We also look at tree buffers. The ag groups through the coalition have been very active in helping producers with tree buffers, biofilters. Sometimes they are needed, sometimes they are a good idea, but that isn't all the time. And there's still a lot of research going on biofilters. Not every operation needs a biofilter. They work with some, they work with others, but you should just take a look at it and see if it works for your operation. Clean pigs and buildings. That's one you don't see on some people's lists of things to do, but you like to keep your pigs clean for a lot of reasons. Don't sell yourself short as producers to what that means to those neighbors, because clean pigs and clean buildings means the manure is not on the pig, it's in the pit. And when the manure's in the pit, it's causing less odor than when it's on the pig. And I think we have research to show that, so don't sell yourself short. Keeping those buildings well ventilated so that the pigs are comfortable means less odor, and you're doing a better job of management that will help with neighbor relations. Manure treatments and additives, we're all aware of a lot of discussion there. And timing of manure agitation and application. Again, each individual situation, you need to do your best to work with neighbors. And you may have other things to add to that list, but I think that's a pretty good general list to start with. Insurance. As I say every year when I'm here, I am not selling insurance. There are people upstairs who are. Please go see those people. If you have a hog operation and you have a standard farm liability policy, and I'm just use the term standard policy, liability policy, chances are that standard policy does not cover a nuisance action. But you should have it reviewed. What I'm talking about, does it cover a nuisance action? If you're sued for nuisance, will you, one, have coverage for any damages that could be entered against you? And two, will your policy pay for people like me, the attorney, to represent you in that case? Have your policy reviewed, find out if it does or doesn't. If it doesn't and you're interested in this type of insurance, there are people out there who sell it. And have it reviewed carefully to make sure it will cover what you want it to cover. And again, there are a number of companies that offer this, and some of them are right upstairs, so please check into it. Any questions on nuisance insurance? And I will tell you that when you read that policy, and I think there's somebody in the room here who sells this, I won't put them on the spot. You can read that policy, and I'll almost bet you it doesn't have the word, one that offers coverage for nuisance, it doesn't have the word nuisance in it. Okay? And am I right? I'm right. I've read a lot of them, and I call it nuisance insurance. It's environmental insurance. The key is it covers the emission of odors that could be found to be a problem, loss of use and enjoyment for the neighbors. It'll talk about bodily injury, personal injury, or property damage, etc. It really is important to have that policy reviewed by someone to make sure you're getting what you need to protect your operation from a nuisance claim. Okay. All right. That's my discussion of nuisance. Any questions about that? All right. I've already used... I always worry about this time, especially what I'm going to talk about for an hour, but as you can see, there's always a lot to talk about, and I don't think we're going to have any trouble filling up the hour today. All right. Now we're on slide 6. This is the set of slides I was talking about on the EPA CAFO rule. Now, as I looked at this slide last night, and I actually prepared them a few days in advance this year, unlike some years, I looked at that title and it says EPA CAFO rule, history. I'm not trying to say the EPA CAFO rule is history, but I wish it was. But anyway, I should have said background maybe. Anyway, all right. Again, if you're like me, when you're representing producers or you're a producer yourself, you know, all this history, all this background, where we've been, that's fine. Just tell me what I need to know right now, though. What do I need to do? And I think I've already told you that. If you're a confinement producer in the state of Iowa and somebody starts talking to you about an NPDES permit, a discharge permit, and I'll say this, I may be going out on a limb, I don't think I am. Don't worry about it right now. If you're a confinement producer, I'm not talking about an open feedlot or a combination operation. We'll talk about those where you have both a confinement operation, and by confinement we mean totally roofed, where the animals do not get outside, hog building, cattle building, the deep dry bedded buildings, etc. But confinement building, if that's what you have on a site right now, with the way things are going with the EPA rule, sit tight. Don't get in a hurry about an NPDES permit. The day may come, but I don't see it anytime soon. Gene, can I put you on the spot? Gene agrees. All right? Now, let's go through, because you hear a lot about this. You hear it from other states. Let's go through to how we got here, so at least we have a little background. 2003, the EPA adopted a rule that required an NPDES permit, which is a discharge permit, if an and please don't get these permits mixed up with the Iowa construction permits or the Iowa manure management plans. You need those. Nothing's changed there. When I say you don't need an NPDES permit, I'm talking about the federal discharge permit that is administered through the Iowa DNR, but that's the permit I'm talking about you don't need. Chances are you've never had one in the state of Iowa for your confinement operation. That's what I'm talking about. I'm not talking about the DNR permits, etc. You still need those if you're going to build an operation and you meet the requirements. Anyway, in 2003, EPA rule required an NPDES permit if you discharged or had no potential to discharge. Well, pretty hard to show you have no potential. Never is very hard to show. A case in 2005, the court struck down the no potential to discharge and said under the Clean Water Act, which is a federal NPDES permit law, I'll call it, you have to have an actual discharge. So threw out the no potential to discharge standard. So EPA goes back to the drawing board. 2008, we have a rule that required a permit, a discharge permit, if you discharged or proposed to discharge. Not no potential, but proposed to discharge. And in years past, I've went through what is proposed to discharge, what that standard meant. But hang on. This year, in March of 2011, this past year, well, I'm getting ahead of myself. First of all, the case. It was filed in response to that rule. Environmental groups and the ag groups filed suit against EPA. Well, what happened in that case? EPA entered into a settlement agreement with the environmental groups. I mean, you'll hear some government people say they know they're on the right track when they make everybody mad. And they did make everybody mad with this rule. They got sued by the environmental groups. They got sued by the ag groups. All right. What did they do? And I'm not going to pull too many punches here because this part of what they did still sticks in my craw. They entered into a settlement agreement with the environmental groups. Okay? And it was issued on May 26, 2010. They agreed, EPA did, to issue a CAFO guidance. And we'll talk about that in a minute. And they agreed to propose a new rule within 1 year that would require all CAFOs, those operations larger than the 1,000 animal unit threshold, which for hogs is 2,500 head, requiring them in this rule that they would, regardless of whether they discharge or propose to discharge, they would have to submit the following information to EPA. And pretty much your name, all this stuff, just information gathering. And again, it's not if you are a CAFO discharging, it's everyone that's above that 1,000 animal unit threshold. They want to require that information to be submitted. They agreed to do that in that settlement agreement with the environmental groups. The agreement was that it would be submitted every 5 years. They will take final action on this proposed rule, and we'll get to more on that in a minute, by May 26, 2012. So they have to take this rule was issued. I've got a slide coming up on that. and they have to take final action according to this out-of-court settlement agreement by May 26, 2012. And they would release all of this information they're going to gather to the public, except information that's confidential. They also agreed to accept a petition for rulemaking if these environmental groups believe that the info shows there are categories of CAFOs that presumptively discharge. That's the key. That's what the environmental groups wanted. They want to put us all in a class that say, even though you haven't discharged, based on this information, you presumptively discharge. And there is some language in one of the court cases that mentions that. But that's what they want. They want to put us all in this category. All right, hold on to that thought. Also, the agreement said EPA, you and I as taxpayers, would pay $95,000 in attorney's fees to these groups. Okay. My objectivity is coming through, I'm sure. Okay, the EPA CAFO rule guidance. This document they agreed to do as guidance. The EPA issued that. They issued that a couple of days after releasing the settlement agreement. And all CAFOs in this guidance document, not a rule itself, but CAFOs were to do an objective assessment of their operations and see that first bullet point, to determine if they discharge or propose to discharge. Notice I have a line drawn through propose to discharge. Stay tuned. Okay. I won't, this assessment was to include these factors. Couple of points here in this guidance I want to mention. All right, this bullet point, slide 13. They talk about exhaust fans and whether pollutants exhausted by ventilation fans will then be transported in precipitation runoff to waters of the U.S. They actually had in their guidance document pictures of feathers from a poultry operation that had been exhausted through the exhaust fan and had settled outside on the ground, and the argument was that those would then be carried away by rain, and that would be a discharge of pollutants to water the U.S. And they said, if so, EPA takes position that the facility, even though it hasn't discharged, is proposing to discharge and must get an NPDES permit because of that exhaust discharge. Notice I have a line drawn through that. Stay tuned. Okay, and then I state in here, however, an NPDES permit is required only if there's an actual discharge. It's kind of my editorial comment. Other key points. Look at that second bullet point, manure application on frozen or snow-covered ground. In this part of the CAFO guidance, they might as well have said, Iowa, pay attention, because Iowa has a law that we're going to talk about that many of you are aware of about applying manure on snow and frozen ground. EPA stated in this guidance document, issued a year ago in May, that said, land application discharges are not exempt. And look at that bullet point. Gosh, I've got a line drawn through it. Considered proposing to discharge if CAFO is operated such that a discharge will occur. And referring to manure application on snow and frozen ground. I don't think we need to cover that last point. Okay. Here's what happened in March of 2011. A federal court struck down the EPA rule that required an NPDES permit if the operation proposes to discharge, and ruled, as in the Waterkeeper case back in 2005, there must be an actual discharge for an NPDES permit to be required. That's why I had lines drawn through all that proposed to discharge stuff. The federal court, threw that part of the rule out. What happened next? All right, remember this reporting rule that was in that settlement agreement? EPA was to have it out in May of 2011. Because of the court's decision, they put it on hold. They did issue it on October. They are asking for comment, or did ask. The comment period closed January 19th, 2012, but they are proposing, as was in the settlement agreement, that CAFOs submit the information required, that list I showed, or their first proposal is to have the state DNRs voluntarily submit the information. So that would be everyone as they propose with the settlement agreement. Or the other option would be to look at specific watersheds that they would designate as high-risk watersheds and ask for that information from those CAFOs in those watersheds. They did propose an alternative, as you see at the bottom of slide 16 here. What if we required the state DNRs to submit that information? Now here's where, we'll see if Gene agrees with me here, or maybe, the Iowa Pork Producers Association submitted comments, as many other groups, and we took the position, the association did, that list I showed you, and I know I went through it pretty fast, but you that have manure management, well, it would apply to if you have more than 2,500 head of hogs. If you have more than 2,500 head of hogs in Iowa, if you've gotten a permit since 2002, you will have or if you built since 2002, you would have a construction permit. In that construction permit, you have a manure management plan. I believe, and somebody here will correct me if I'm wrong, but I believe everything the EPA wants is in that information. Gene, am I close? Okay, what Gene just said, for those of you who will be listening to this on the Swinecast, is that the information EPA is proposing, this is all a proposed rule, nothing final yet, what they're proposing, that DNR has it in their database that is actually accessible to anyone who wants to get online. DNR has everything except the land area that they are requesting. That is in the manure management plan, so that it is in DNR's possession, but it is not on the database. Okay. I guess the position the association took and others is producers have enough regulation and reporting to do right now. First of all, scrap the rule. We don't think it's necessary. But number two, if it's going to go forward, get the information from DNR. We've already given it to them. Don't require us to submit it again. Our producers don't need another deadline to meet. They don't need something else they have to report. Get that information through them. So, I don't know if anybody else has any thoughts on that, but that's where that stands right now. Just a few other things. December 8, 2011, the Office of Management and Budget issued a notice regarding the proposed reporting rule under the Paperwork Reduction Act and disapproved of that rule. It said it is not clear that the reporting and record-keeping requirements associated with this proposed rule have practical utility and reduce to the extent practicable and appropriate the burden on persons who shall provide information to or for EPA. So we'll see where the OMB reminded them to keep an eye on this as they develop the final rule. And that would also apply to the information they're trying to, if they ask DNR to provide it. Also, on December 8, 2011, there was a memo that was issued to the regional EPA offices. And to me, this is important. It's not a new rule, but it shows how EPA is looking at the federal court case. They said, in response to NPPC, because there was a question whether they would fight this battle in other federal judicial districts, not just the district that this court decision came from, the National EPA Office said, we will revise the CAFO regulations to remove the proposed discharge standard and will update the implementation guidance, the one that I was talking about, to provide guidance consistent with the court's decision. Okay? Let's see. I just have a few more things on the EPA, and then we'll get to the DNR stuff where I think we're doing pretty well on time. I mentioned this, I've been talking about this, the EPA CAFO rule, what is called a large CAFO, where the NPDES requirements kick in. Now, there are some that are required to have it at less than that. Mainly, we look at open feedlots there. But generally, for confinements, we're looking at 2,500 head of swine weighing 55 pounds or more, or 10,000, in essence, nursery pigs. That's when you'd have to worry about what I was talking about. Here's the EPA CAFO rule that it said you must obtain a federal discharge permit if the CAFO discharges, and I've crossed out or proposes to discharge because that was struck down. Iowa confinement operations cannot discharge by law. And so in essence what we're saying is, why would Iowa confinement operations need a discharge permit if they can't discharge by Iowa law? And that's really the essence of the argument in Iowa. We don't need this. Iowa DNR handles it. If we have a discharge, Iowa DNR brings enforcement actions when necessary. It's all handled actually stricter than what federal law is, so we don't need the federal discharge permit. Okay. But discharges also include discharges from land application, not just from the facility itself, but there's also an exemption there. I'll cut to the chase. If you have a manure management plan, and which you do, you have to if you're that size operation, and you apply according to that plan, it's site specific, then you have an exemption if they're from the needing an NPDES permit. You don't have an exemption from if you cause a pollution event, and DNR will come knocking if that happens. And my last bullet point there, this plan I'm talking about under the EPA NPDES permit is not required to be submitted to EPA or DNR, but state law requires you to submit it. You don't have to do it as far as the EPA is concerned. I worry about getting into this detail. I'm going to confuse someone again. Don't confuse this. I'm talking about what's required under this EPA NPDES permit, okay? And right now I've said we don't need it. Do you need one if there's an accidental discharge? Short answer is no, and EPA has repeated this again and again and again. If you have a discharge, hose breaks when you're applying manure or whatever, that is a discharge. Okay, gets into water of the state. Is that something that now requires you to have an NPDES permit from the federal EPA through Iowa DNR? No, if you change or correct the conditions that caused it. Okay? So the key, and I hope you don't find yourself in this position as a producer, but if you have a discharge, you deal with a DNR enforcement action or whatever, make sure the order that you either agree to or that you work out with the DNR has something in it about what you're doing to correct what happened. Okay? Gene.
So, like if you did have a hose break, what would you do to correct that so it doesn't happen again?
The question was, if you have a hose break, what do you do to correct that to at least satisfy EPA that, and you, DNR, that we don't need an NPDES permit? In other words, correct it so that it doesn't happen again. I believe the thing you do is you implement a protocol, so to speak, that you're going to pressure check hoses before you start every fall. You're going to do a daily check. You know, the kind of things that you may have been doing anyway. Did I miss anything on that list? That's what, tell them what you're going to do. We know you can't go back and change what happened. You can't do that. But to correct the condition or that occurred, put in procedures. Like we do have spills sometimes where a agitation pump, the producer leaves it running while they're out in the field, and the spout moves or something and it starts shooting over the edge of the lagoon or whatever. If that happens, put in a procedure, a protocol for your operation that you're not going to leave the pump unattended. And you should have that protocol there anyway. So those are the things you have to do to show that you've changed or corrected what caused the spill. Okay? And you may be able to think of others. All right. No discharge certification option. I'm not going to spend any time on this. This was in the EPA CAFO rule. Well, Gene, has anyone done that you know of? He's shaking his head side to side, meaning no. And I'm not aware of anyone in Iowa who has submitted the information to get this certification. I'll leave it to your reading. If we have time and anyone wants to talk about it, I'll be glad to come back and cover this. At this time, with the uncertainty in the federal rule, I don't see the advantage in doing it. But when I talk about not doing some of these things and not needing a federal discharge permit, etc., the key is go ahead and manage your operations as if you had one. Do the best job you can on not to have a discharge, obviously, but we don't need a federal permit to tell us to do that. By law, we can't discharge. Do what you have to do to comply with Iowa law and go above and beyond that. We're trying to avoid another permit from another government agency here. Okay. Slide 25. Draw a circle around this because if there's anything that I should have, when I said don't worry about any of this, this is one that can catch some people. If you have, say, a 3,600 head hog site, and you've got maybe, a few beef cattle in a lot there, feedlot cattle, I don't care what it is, 50, 100 or whatever, and you have exceeded the threshold with your hog operation, which is a confinement which can't discharge, you may think, no problem. This is where EPA can get you because that small feedlot, which by itself wouldn't require an NPDES permit, does because you've triggered it with your hog operation. And it doesn't just have to be cattle. It could be outside hogs or whatever. If you trigger the threshold with your confinement operation and then have a small open feedlot on the same site, and EPA is conducting flyovers. They have been doing this for several years. They will get in a small plane and they will fly around parts of Iowa, and they will look at these operations, and if they see that, what they think is a confinement building that looks big enough to be over the threshold, and they see that small feedlot, they could well come to see you then. So that's where you need to be careful. Gene. Okay. Gene has asked me if regarding state revolving funds, and I don't have that here, but Gene, if you don't mind, if you just give a thumbnail sketch of it, I'll repeat it here for everyone, because I do think that's important. So if I'm to sum up what you said here, Gene, is for purposes of those watching this on Swinecast, would be that not only do you have to watch the EPA CAFO rule for NPDES permit, you also have to keep an eye on that if you wanted money for that small feedlot to institute controls or something because your hog operation kicks you over the threshold to be a large CAFO, you can't do it. So some people have gotten surprises on not being able to get state money or low interest money under what's called the SRF or state revolving fund. All right. Okay. That's the conclusion of the EPA discussion. Kent, and you and I talked briefly about this. That mixed animal CAFO thing was one that I think we see a fair amount. Gene's talked about it. That where it catches people because you think, okay, just have that few head outside, but what throws you over the threshold is your confinement operation. Okay. Anything else? Anyone on that? All right. Let's move on to Iowa DNR regulation. Again, as I told you, I'm just going to cover some of the points that were raised by the new rule, not this past September, but the September before, September 2010. If you have hoop buildings, and I use the term hoop buildings to talk about, the dry bedded buildings, they may be monoslope, etc., but something with dry manure in them, not the typical slatted buildings. Often we see these with cattle, a lot with hogs too. The rule that we have is, here I give you what is a confinement, what is an open feedlot. I've talked about that. But in 2010, the DNR adopted a rule of what is a partially roofed animal feeding operation. First, you see some of these dry bedded buildings where they will have a space a lot outside for either hogs or cattle. I see this a lot with hogs. And on the bad days, when the weather's bad, they close the gate and don't let the hogs outside. According to this rule, the animals, to be an open feedlot, they must have unrestricted access outside. Okay, we run into this with dairies too. The second thing under the rule is the unroofed area must be at least 10% of the square footage of the inside area. If the outside area has to be at least 10% of the inside area. Okay? So, you see some of these operations which were built that just put a little bit outside. Maybe for cattle, you see the feed bunks outside, right? If that's not more than 10%. Now, if it was already built, you are okay as far as a construction permit or other confinement requirements. But and Gene, you correct me if I'm wrong, or DNR's position is if you have one of those that was built before, even some that received a permit from DNR as an open feedlot, not a confinement, but if it's less than 10% now, DNR expects and requires those operations to get a manure management plan as a confinement. Is that right? Oh, well, or get more than 10% outside. Okay. So, be aware of that. It's caught a few people, and I'm not bashful. I don't agree with DNR's position. I think if that operation was there before, they should be grandfathered in and not be required to get an MMP, but that's not DNR's position, and I can see where they come to their position because there is no statement in the rule that says you're grandfathered in. I still believe as a matter of law you should be, but what I believe in this area doesn't really matter right now. If you know of someone with that situation, they should be aware that that DNR will inform them they need an MMP or, as Gene said, expand the outside area. Okay, on to one of the areas, a lot of the questions I get now, and I had the question before we started today whether I was seeing much expansion, construction going on, and yeah, I think there is a fair amount of building going on. I see people shaking their heads, yes, especially in southeast Iowa. Maybe I shouldn't pick out areas of the state, but northwest, are we seeing? Kent is saying we're seeing it all over the state. usually, and I've said this before, I was on WHO at noon yesterday, and one of the things I said why I think it's kind of quiet on the regulation front is we haven't had a major change in either code. Well, code we haven't had a major change since 2002. Rules we haven't, this rule in 2010 had a lot to it, but it was what I would call more details, nothing, a major change as far as substance. But I think one of the good things for producers, why this room isn't filled right now, is we don't have new regulations to have to worry about right now. We've had consistency, not a lot of changes, and I think that's good for the industry, good for everyone. Not that we agree with what's there, but I think just not having a lot of changes all the time helps everyone. It helps producers know what they need to do, etc. So I'm not getting a lot of calls right now, which is probably good. Usually the calls I get are when something's broke. But one of the calls I do get is this adjacency issue. And Gene mentioned it here a little bit ago. How far apart do you have to be one operation versus two? And I'm not going to go through all the details here, but one of the, there were a couple of rules that went into effect in 2010 was if you have the same manure storage for, let's say, 2 buildings, same manure storage, obviously if it's the same confinement structure or a stockpile that's used together, etc., that means it's a common area or system for manure disposal. That means it's one operation. But if you have the same manure application fields in your manure management plan for 2 sites, that factor by itself does not make you one operation for DNR purposes. Okay? It doesn't mean that makes you one site. And I think there are quite a few operations out there that do have the same fields in 2 different MMPs. Now, how does EPA feel about that if they're trying to drag you into being one operation to argue you need an NPDES permit? I'm not sure it's as clear cut with EPA. I think they will give some respect to Iowa's law that says you're not one operation, but they often reserve the right to take their own look at it. Gene's shaking his head yes, so I assume that's still EPA's position. The last time I fought the battle with them here, that is their position. Okay? They will reserve the right to look at other factors. Okay, here's one. Draw a circle around this if you haven't already. Used to be under the DNR rules that if one contract owner of pigs had their pigs in producer A's buildings and producer B's buildings, and they were within the 2,500 feet adjacency distance, if that's the distance that applied there, that would make you one operation because DNR considered that significant control over the day-to-day operations being common management. That rule changed last year, so now it is clear the control by an owner of animals being fed under contract in 2 or more CFOs or open feedlots does not make it common management. And maybe you're aware of that, but that was a very good rule change we had last year. Okay, another one. Sometimes you see buildings built. The second point here, I'm on slide 31. Used to be you had to wait a year after building a site or construction on a site that didn't require a permit. You had to wait a year before you could expand that site and get a permit. Now it's 120 days. Again, a very positive rule change there. Slide 32. This would go in my column of not a good rule change, but maybe it's not that hard to deal with. Any changes to the design during construction must be DNR approved first. The rule previously said, if I'm recalling correctly, that there could be changes by the engineer. There was some question about it, exactly how the rule was implemented. This clarified it that if your engineer or you make any design changes from the plans you submitted to DNR with your permit, DNR has to approve them first. Gene, has that been an issue much? Have you seen this change? Okay. Anyway, Gene says no, he hasn't really seen this be an issue. But be aware of it so that you don't get caught after the fact. Okay. This is one we ran into problems in years past when often when you submit an application for a permit, the producer may not have bought the site yet to build the buildings, and they don't want to buy the site until they know if they can get a permit. So they would enter into an offer to buy or some sort of contract like that, and EPC had taken the position and denied several permits in years past that You don't own the site, you're not the legal owner, so therefore you can't be the permit applicant. That has been changed. Now it says the owner means any person who has legal or equitable title, which, as I state here in the a purchase contract contingent upon the permit being issued should qualify. Notice I used the word should. Anyway, soils report with earth and manure storage. Second bullet point there in slide 34. You must control berm erosion with perennial grass on the berms. Gene, let me ask, what is the situation with DNR doing annual lagoon reviews? Are they? I think that has been a requirement. I know with staffing cuts, etc. I don't know that that's still being done. I wanted to ask you. And what Gene said is they're trying to comply with the requirement that they do an on-site inspection of each lagoon each year, but with staffing cuts, etc., it may not always get done, but you're trying to comply. It wasn't a question designed to get you in trouble there, Gene. It was just a question because I think producers with lagoons need to be aware that DNR will most likely be around to do annual inspections, and this requirement about perennial grass is one of the things they'll be looking for. Okay. And other erosion control materials. I'm going to go to, if I skipped over something you want to see here, I'll be glad to talk about it afterwards. Slide 36. MMPs upon transfer of the operation. The rule is now clear that you have to have a new MMP within 60 days. You can use the existing MMP for manure application until then. So, if the operation is sold, even if nothing is changing as far as where the manure will be applied, etc., you still need a new MMP within 60 days. Slide 37, DNR is no longer sending reminder notices of the annual updates. We always have the compliance fee issue that under a contract feeding arrangement, it is the livestock, by law, the livestock owner is required to pay the fee. And bottom bullet point, slide 37, the phosphorus index must be recalculated every 4 years, more often if the phosphorus index inputs change. Tom Miller, when you and I were talking ahead of time, Tom Miller Extension, Southeast Iowa, this is one thing you see that catches some producers. They have been submitting their annual updates that say no changes, and along comes the phosphorus index, and then they got to get soil samples taken, etc. Right? Okay, Tom said that fourth year sneaks up on people. So keep that in your calendar of when that comes around so that you do have to submit an MMP with the phosphorus index recalculated. Okay, anything to add on that? All right, manure applicator certification. The 2010 DNR rule there, the top bullet point, slide 38, a confinement site applicator who misses a course 1 year must pass the exam to remain certified. So don't miss the course. All right. Now we're moving out of anything on the general DNR rules that I talked about, the changes. Any questions about that? We are getting close to our time of 10:15. I know you may have commitments elsewhere. There's no one in the room right after us, so I'll be glad to take the time we need to go through these. I want to talk about the frozen or snow-covered ground issue. This is legislation that went into effect July 1, 2009. The fall of 2009, early winter of 2010 was one of the worst we had. The rule got tested right away. Last year wasn't quite as bad. This year has been one that I don't know that, Gene, have you had any calls on the rule this year? Okay. But we do need to keep it in mind. And what are the requirements? First of all, slide 40, what does it not apply to? Open feedlots, dry manure, liquid manure from confinements with less than 500 animal units, the SAFOs. And here's the key. Why doesn't it apply even this year when we do have some ground that could be considered frozen or in places and we'll talk about what frozen means, but if you can inject or incorporate on the same day, even if there's some snow on the ground or what, if you can inject it, if you can get that done, then the law doesn't apply to you. If you can get it injected or incorporated, that's an exemption. Okay. The law is from December 21 to April 1, here on slide 41, you cannot apply on snow-covered ground. This is liquid manure from a confinement. frozen ground is February 1 to April 1. So we are right now, of course, under the snow-covered restrictions. What is snow-covered? There, the bottom bullet point, at least an inch of snow or a half an inch of ice. Frozen is the bullet point above that. Impermeable to soil moisture and does not include ground frozen only in the top 2 inches or less. So those are the requirements, those are the dates. 2 keys I always point out. If it's frozen before the date of February 1 to April 1, no snow cover, but it is frozen, you can go ahead and apply. The restrictions on frozen ground don't apply till February 1 to April 1. Likewise with the restrictions on snow-covered ground. If it's snow-covered before December 21, you still have to be careful not cause pollution, but these restrictions don't apply. So the restrictions only apply within the dates, and then even within the dates, they only apply if the conditions are present to make it frozen or snow-covered. So we don't have a situation where we have hard and fast dates no matter what the conditions are, nor do we have a situation when you're outside of those dates and the conditions are present that the law applies. So again, I think it's something to just be careful of because it's hard to keep track of all this, I know, when you're out there trying to get the job done. We talk about an emergency. It doesn't apply if there's an emergency, and that's a need to apply due to unforeseen circumstances, and unusual weather is one of those. Slide 43, to apply liquid manure on frozen or snow-covered ground due to an emergency, a producer must call the DNR field office before application, give all your information, and then apply the manure on land identified in the MMP, either in the original MMP or the next updated MMP, and a P-index of 2 or less. So when I said it doesn't apply, I mean, if you have an emergency, you are subject to the law. It's just you're not prohibited from doing it. You have to follow these requirements, okay? The question was, if they get in a bind and rather than apply on frozen or snow-covered ground, can they haul from one site to another, right? Right. So the law doesn't apply because you're not land applying it. But you still have to, I would encourage people to contact DNR, tell them what you're doing. You're hauling from one site to another so that there aren't any questions about that. And then, yes, my understanding is you can do that. Gene? He's shaking his head yes. Is it a good idea to let the DNR field office know? He's also shaking his head yes. So, yeah, the law on restrictions on snow or frozen-covered ground application do not apply because you're not applying. But you have to look at where you're hauling that manure to. Okay? There are some operations out there that when they were built, they didn't have enough storage to get through the winter, and so they have to apply. And if the ground is frozen or snow covered during these dates, right now the law says, the second, or I guess third bullet point there, that right now they can do it even though they don't have enough storage, but beginning December 21, 2015, they must have enough storage to avoid application during those time periods. Okay? And I assume if you're getting any call, I mean, that's a lot of the calls you get, isn't it, Gene, from those that don't have enough storage? And that they are allowed to use the emergency procedures at this time. But if we know of producers like that, this December 21, 2015 date is coming up, so they need to be planning for additional manure storage. Okay. Other considerations, slide 45. Does it comply with EQIP requirements? What about federal NPDES permit requirements? Of course, the guidance will be changed regarding, as we talked about, whether it's considered proposed to discharge, because that standard is gone. Also, some operations have a master matrix that took points for injection or incorporation to surface supply. Because of an emergency, they must obtain written approval or a waiver from DNR. So they have an additional requirement there. And then always follow good community and neighbor relations. Stockpiling dry manure, I think I'll skip over that for now. And if somebody has any questions, not that it isn't important for a lot of these dry bedded operations, but there are 4 different categories. I lay out what the 4 categories are, and then of regulation. And then in the slides that follow, I talk about the dry bedded confinements, hog and cattle, what they can do as far as stockpiling. Again, stockpiling is very important to a lot of these operations. Just pay attention to these rules and don't get confused between the 4 different categories. I think there's a couple of fact sheets out there, but most of the questions I get are confusing one category to another. All right, appeals of construction permits to EPC. Hopefully we won't have any of these. We haven't had any for a while. Here are the rules that apply if you apply for a construction permit, the county, or if it is approved and the county appeals it to the EPC and challenges that, here's how those appeals are handled. Okay? Slide 50, my annual admonition on open burning. I haven't seen one for a while, but usually when DNR goes out on a site inspection, for some other reason, if they see a quote-unquote burn barrel there, anything that shows you're burning something at the site of a hog operation, they will look to see what you are burning there, and if there is no house anywhere in sight, they will come to the conclusion that you're burning something that is not household waste, and you can't do that. And I've seen producers get written up for that. If your house is on the same site as your hog building, they will go over and look in that burn barrel and see what is, you can burn household waste, but if there's a bottle of, a discarded bottle of medication there, I'm using that term broadly, they will probably make sure it's not any human medication of any kind, and then they will, of course, come to the conclusion that you have burnt something from the hog building that is not household waste. And again, that is a violation of Iowa law, and you will be written up for that in many cases. I'm not trying to be hard on DNR field inspectors here, but I have seen that in enforcement orders. Pay attention to the open burning restrictions because it's a surprise to many producers. Slide 51, here we go. My DNR enforcement environmental self-audits. I say I'd like to remind this about every talk I give on regulations. It's your get-out-of-jail-free card. If you discover at any time that you have violated Iowa DNR rules, either something I said today or whenever, do a self-audit. What is a self-audit? Look at the rules yourself or work with a consultant. As a result of that audit, one, you can notify DNR of that audit at the time you do it. That's kind of a formal process if you do that. You can do it right away. Tell them, send them a letter as required by the rules that I'm conducting a self-audit. You can go ahead and do that then. Or you can conduct your audit, and if you discover a violation of the rules, then you send DNR a notice that you're conducting a self-audit and a notice that you discovered a violation. The rules lay out how you're supposed to, what has to be in that notice. If you do that properly and tell them how you're going to correct the violation, there will be no penalties. And DNR, this is a process that must be followed. Otherwise, if you just call DNR and tell them, I think I have a violation, you're putting them in a tough spot because you haven't followed the law for self-audits. And you may get a penalty, you may not, but the best thing, follow the self-audit procedure and you can get immunity from penalties, get the situation fixed, and away you go. One of the examples we see is when an operation needs an MMP, didn't know it, didn't realize it for whatever reason. They find out on their own. DNR, you can't do it if DNR finds out about it first. Do a self-audit and you will avoid penalties. Penalties for not having an MMP, if DNR discovers at first, range usually from $3,000 to $5,000. Okay? Don't forget the self-audits. Okay. I am 10 minutes over my time, but the next topic I talked about were the on-farm oil spill prevention plans for EPA. This is not a livestock issue. This is a general farm issue. How many of you were aware of these? Anyone working on them? Or Gene, I assume you don't get involved in these, so Gene can kick back and relax now. But pardon me? Gene says he's ignorant on that. Well, wait a minute. Don't you have fuel barrels out there? Small ones. All right. All right. I think if there are questions about these, Iowa Pork and others have put information out on what you need to do. We've got several articles on that. that have went out. If you want a copy of the article, we'll be glad to get that to you. You have these slides. Again, the deadline was November, this past November, and the EPA extended it not to May 2012, but May 2013. Now that's to update your plans if you needed one before, if you fit the category. First of all, you look at the size there in slide 52. If you store more than 1,320 gallon above ground or more than 42,000 gallons below ground, then you qualify as a farm that must do that. And then if you began operation after August 16th of 2002, then you have until May 10, 2013. If you began operation before that, you're already required to have one, so you should have it done now, but you have until May 10, 2013 to update. Here's some of the requirements in slides 54, 55, and 6, and 7, 8. I'll let you read those. You have the copies. If you have any questions, I'll be around afterwards. I see a hand going up in the back now. I believe I have to look at this. I don't believe portable is included, but does anyone else know for sure this? I don't think portable is included, but let me look and I'll be glad to talk to you afterwards. Is that all right? I did see, Gene? Oh, I did see, not to plug somebody else's conference or seminar, but the Iowa Power Farming Show next week, there is a presentation on this I saw, I think on Thursday of next week by an engineering firm. So I know we have that in our information here somewhere, but as I look here quickly in the slides, I'm not seeing it. So don't quote me on what I just said, even though I'm on tape. But we'll take a look on portable. I'm pretty sure it's in our article, and I'm just not seeing it right now. All right? Any other questions? Gene? I'll be glad to mention it. What Gene has asked me to do, kind of what do I see in the legislature right now? Right now, there is a bill proposed in the legislature. It was introduced last week that well, let me back up. What we're seeing are some sow units that are good sized. I need to back up even more. In 1995, when these laws first went into effect, there was a cap that was put on the size of confinement operations before you needed aerobic treatment of manure. And at the time it was enacted, it was pretty well known that aerobic treatment was not an economically viable or technically viable option. So it was in effect a cap on how large operations could get in Iowa. There are various categories. In 2002, those categories were amended to comply with the animal units. But what we're seeing for sow units, just farrowing and gestation, that cap is 2,500 animal units, which is 6,250 sows. And of course, that includes, you have to include any animal that's over 55 pounds in calculating that. What we're seeing sow units wanting to do, because of biosecurity reasons, many sow units anyway are going to on-site gilt development versus off-site. So when you have off-site gilt development, then you can have your 6,250 sows on that site and not hit the aerobic treatment requirements, which even today, I'm not aware of anyone using aerobic treatment on a swine operation. I've seen people try it, but I haven't seen it work. So it still is in effect a cap. This bill, recognizing that operations are wanting, because of biosecurity reasons, to bring the gilt development on site, this bill would allow you to still have your 6,250 sows, but bring the gilt development on site and not have to count those towards your cap. That's what the bill would do. It's still under discussion. Gene, I think the DNR has looked at it carefully. I won't say, you willing to state DNR's position on it? Or? They have no position. Okay. I think, again, it's something there will be some concern about because of the size of the operations and not counting those towards the cap. But it is looking at we're not expanding anything. We're just bringing what was off-site on-site because of biosecurity concerns for disease. And I say biosecurity, that's for the pigs, of course, because of disease concerns. So that's what's being looked at. Other legislation, I don't know of anything right now, but Stay tuned for those of you that follow that through your organizations, Iowa Pork.